Your rights as a hospital patient in New York State. If you think you are being asked to leave the hospital too soon, you have the right to appeal decisions made by your doctor, hospital staff, or your managed care plan about when you are to leave the hospital. If you feel you are being asked to leave the hospital too soon, if you believe you have not been given adequate or appropriate plans for your medical care and other services you may need after you leave the hospital, or if needed services are not in place. The law requires that you receive advance notice in writing telling you the date the physician and/or hospital plans to discharge you, how to appeal if you wish to remain in the hospital, and a special number to call with any problems related to leaving the hospital. For Medicare patients only, if you feel that you are being asked to leave the hospital too soon and have not received advance notice telling you when to leave the hospital, ask for your discharge notice, also called a Hospital-Issued Notice of Non-Coverage, or HINN. If you are in a healthcare maintenance organization, an HMO, request a Notice of Discharge and Medicare Appeal Rights, the NODMAR. You must have this written discharge notice in order to appeal the physician's and hospital's decision about when you are to leave. For managed care patients, if you are a patient enrolled in an HMO or managed care plan, first request, submit an expedited appeal to the HMO or Plans Utilization Review Committee if you feel your benefits are unfairly limited or denied, or you are being asked to leave the hospital too soon, or that medically necessary services are inappropriately excluded from your coverage. If you are not satisfied with the outcome of that appeal request, you may contact the New York State Department of Health by calling 1-800-206-8125. The Managed Care Law of 1996, amending Public Health Law 4408, Disclosure of Information. You have the right to file a complaint about doctors or physician assistants. If you feel that you have received incompetent, negligent, or fraudulent care from a doctor or physician assistant, you may file a report with the New York State Department of Health Office of Professional Medical Conduct, OPMC. OPMC investigates all reports of possible professional misconduct by physicians and physician assistants. Reports must include the full name and address of the doctor or physician assistant and all relevant information. Reports must be made in writing to New York State Department of Health, Office of Professional Medical Conduct, Headley Park Place, Suite 303, 433 River Street, Troy, New York, 12180-2299. For more information or to obtain a complaint form, call 1-800-663-6114 or visit the Department of Health website at www.health.state.ny.us. Reports are kept confidential. An investigation may result in a formal hearing before a committee of the Board for Professional Medical Conduct. The board consists of physicians and consumer members appointed by the Commissioner of Health. You have the right to file a complaint about other healthcare professionals. If you feel you've received incompetent, negligent, or fraudulent care from any other licensed healthcare professionals, such as nurses, dentists, social workers, optometrists, psychologists, physical or occupational therapists, and podiatrists, you may file a complaint by contacting the New York State Education Department, Office of Professional Discipline, 475 Park Avenue South, 2nd floor, New York, New York, 10016, or call 1-800-442-8106. Questions or complaints about your hospital bill or health insurance. As a hospital patient, you are entitled to an itemized bill. Your hospital bill may identify a charge called a surcharge. These surcharges fund important public programs and have existed in previous years, although they may not have appeared as separate costs on the bill. The surcharge represents an additional amount due on total hospital bills in New York State and, depending on your insurance contract, New York State law allows a portion of these costs to be billed to you. Hospitals negotiate payment rates with insurers, HMOs, and other types of managed care plans, as well as commercial insurers and self-insured groups. These rates may vary. Contact your insurer with any questions you may have regarding your coverage. If you have questions about your coverage, the service billed or amounts paid, contact the hospital's billing office and your insurer to resolve any questions or problems that you may have. For Medicare patients, if you are a Medicare patient and have questions about your hospital bill, call your Medicare carrier at 1-800-633-4227. For managed care patients, if you are enrolled in a managed care plan and you are having trouble getting care or feel your care is not satisfactory, you may complain to the plan. The plan's handbook must tell you how to complain and how to get an immediate review. If you are not satisfied with the HMO or plan's response to your complaint, contact the New York State Department of Health at 1-800-206-8125. Medicare managed care enrollees may call the IPRO Beneficiary Complaint Hotline or their HMO regarding quality of care issues. Call 1-800-331-7767. Access to your medical records. New York State law requires all healthcare practitioners and facilities to grant patients access to their own medical records. Section 18 of the Public Health Law contains procedures for making these records available and the conditions under which a provider can deny access. Patients may request information in writing, as may parents or guardians who have authorized their child's care. If you want to see your medical records, ask your doctor and/or the director of medical records at the hospital. New York State law guarantees you the opportunity to inspect your medical records within 10 days of your written request. If you want to have a copy of your medical records, you must submit a written request to the hospital. Address the request to the Director of Medical Records at the hospital. If you request a copy of your records, the hospital may charge you up to 75 cents per page. If the hospital fails to acknowledge or act on your request, you may complain to the Department of Health by calling 1-800-804-5447. If you have been denied access to all or part of your hospital records, you may appeal to the New York State Department of Health Medical Records Access Review Committee. The hospital or doctor is required to provide a Form DOH-1989 that gives the reason or reasons for denial and information on this appeals process.
Important message regarding your rights as a hospital inpatient. Your rights while a hospital patient. You have the right to receive all of the hospital care that you need for the treatment of your illness or injury. Your discharge date is determined only by your healthcare needs, not by your DRG category or your insurance. You have the right to be fully informed about decisions affecting your care and your insurance coverage. Ask questions. You have the right to designate a representative to act on your behalf. You have the right to know about your medical condition. Talk to your doctor about your condition and your healthcare needs. If you have questions or concerns about hospital services, your discharge date, or your discharge plan, consult your doctor or a hospital representative, such as the nurse, social worker, or discharge planner. Before you are discharged, you must receive a written discharge notice and a written discharge plan. You and/or your representative have the right to be involved in your discharge planning. You have the right to appeal the written discharge plan or notice you receive from the hospital. If you think you are being asked to leave the hospital too soon, be sure you have received the written notice of discharge that the hospital must give you. You need this discharge notice in order to appeal. This notice will say whom to call and how to appeal. To avoid extra charges, you must call to appeal by 12 noon of the day after you receive the notice. If you miss this time, you may still appeal. However, you may have to pay for your continued stay in the hospital if you lose your appeal. Discharge plans. In addition to the right to appeal, you have the right to receive a written discharge plan that describes the arrangements for any future health care you may need after discharge. You may not be discharged until the services required in your written discharge plan are secured or determined by the hospital to be reasonably available. You also have the right to appeal this discharge plan. Admission notice for Medicare patients. You have the following rights under the New York state law. Before you are discharged, you must receive a written discharge plan. You or your representative have the right to be involved in your discharge planning. Your written discharge plan must describe the arrangements for any future health care that you may need after discharge. You may not be discharged until the services required in your written discharge plan are secured or determined to be reasonably available. If you do not agree with the discharge plan or believe the services are not reasonably available, you may call the New York State Health Department to investigate your complaint and the safety of your discharge. The hospital must provide you with the State Health Department's telephone number if you ask for it. Important message from Medicare about your rights. As a hospital inpatient, you have the right to receive Medicare-covered services. This includes medically necessary hospital services and services you may need after you are discharged if ordered by your doctor. You have a right to know about these services, who will pay for them, and where you can get them. Be involved in any decisions about your hospital stay, and know who will pay for it. Report any concerns you have about the quality of care you receive to the Quality Improvement Organization. Phone 1-800-446-2447 or area code 516-326-6131. Your Medicare discharge rights. Planning for your discharge. During your hospital stay, the hospital staff will be working with you to prepare for your safe discharge and arrange for services you may need after you leave the hospital. When you no longer need inpatient hospital care, your doctor or the hospital staff will inform you of your planned discharge date. If you think you are being discharged too soon, you can talk to the hospital staff, your doctor, and your managed care plan, if you belong to one, about your concerns. You also have the right to an appeal, that is, a review of your case by a quality improvement organization. The QIO is an outside reviewer hired by Medicare to look at your case to decide whether you are ready to leave the hospital. If you want to appeal, you must contact the QIO no later than your planned discharge date and before you leave the hospital. If you do this, you will not have to pay for the services you receive during the appeal, except for charges like copays and deductibles. If you do not appeal, but decide to stay in the hospital past your planned discharge date, you may have to pay for any services you receive after that date.
Deciding about healthcare, a guide for patients and families. Who should listen to this guide? This guide is for New York State patients and for those who will make healthcare decisions for patients. It contains information about surrogate decision-making in hospitals and nursing homes. It also covers DNR orders in a healthcare facility or in the community. Because this guide is about healthcare decision-making, the word patient is used to refer to anyone receiving medical care. This includes a nursing home resident. This guide does not include the special rules for healthcare decisions made by legal guardians of persons with developmental disabilities. Question: can the patient or other decision maker find out about the patient's medical condition and propose treatment? The answer: yes. Patients or other decision makers have a right to be fully informed by a doctor about their medical condition and the doctor's proposed treatment. Patients must give informed consent before any non-emergency treatment or procedure. Informed consent means that after information is given about the benefits and risks of treatment, as well as alternatives to the treatment, permission is given to go ahead with the treatment. Adult patients who have the ability to make informed decisions. Question: do adult patients have the right to make their own healthcare decisions? Answer: yes. Adult patients have the right to make treatment decisions for themselves as long as they have decision-making capacity. Question: what is decision-making capacity? The answer: decision-making capacity is the ability to understand and appreciate the nature and consequences of proposed health care. This includes the benefits and risks of, and alternatives to, proposed health care. It also includes the ability to reach an informed decision. Question: what if it's unclear whether or not a patient has decision-making capacity? Who decides whether or not the patient has that capacity? The answer: healthcare workers will assume patients have decision-making capacity unless a court has appointed a legal guardian to decide about healthcare. A doctor will examine the patient if there is good reason to believe the patient lacks capacity. A doctor must make the determination that a patient lacks the ability to make healthcare decisions. Another person will make healthcare decisions for the patient only after the patient's doctor makes his determination. Question: do family members always make healthcare decisions whenever patients lack decision-making capacity? The answer: no. Sometimes patients have already made a decision about a procedure or treatment before they lose the ability to decide. For example, a patient can consent to surgery that involves general anesthesia before receiving anesthesia, which would cause them to lose the ability to decide. Other times, a healthy person may suddenly lose capacity. In this case, health care may need to be given right away without consent. For example, a person may be knocked unconscious during an accident. Healthcare providers will provide emergency treatment without consent unless they know that a decision has already been made to refuse emergency treatment. Advance directives, healthcare proxies. What is an advance directive? The answer: advance directives are written instructions about healthcare treatment made by adult patients before they lose decision-making capacity. In New York State, the best way to protect your treatment wishes and concerns is to appoint someone you trust to decide about treatment if you become unable to decide for yourself. By filling out a form called a healthcare proxy, this person becomes your healthcare agent. Before appointing a healthcare agent, make sure the person is willing to act as your agent. Discuss with your agent what types of treatments you would or would not want if you were in the hospital and had a life-threatening illness or injury. Make sure your healthcare agent knows your wishes about artificial nutrition and hydration, being fed through a feeding tube or IV line. You can get more information about healthcare proxies at www.health.state.ny.us/professionals/patients/health_care_proxy/index.htm. Some patients also express specific instructions and choices about medical treatments in writing. A written statement can be included in a healthcare proxy, or it can be in a separate document. Some people refer to this type of advance directive as a living will. Question: how do healthcare agents make decisions under healthcare proxy? The answer: healthcare agents make decisions just as if the healthcare agent were the patient. The healthcare agent makes healthcare decisions according to the patient's wishes, including decisions to withhold or withdraw life-sustaining treatment. If the patient's wishes are not reasonably known, healthcare agents make healthcare decisions in accordance with the patient's best interests. Question: can a healthcare agent decide to withhold or withdraw artificial nutrition or hydration through a feeding tube or an IV line? The answer: healthcare agents can only make decisions to withhold or withdraw artificial nutrition and hydration under the healthcare proxy if they know the patient's wishes about the treatment. But the healthcare agent may also be able to make this type of decision in a hospital or nursing home as a surrogate from the surrogate list set forth in law. Healthcare decision-making in hospitals and nursing homes. Question: how do adult patients with decision-making capacity make decisions in hospitals and nursing homes? The answer: patients may express decisions verbally or in writing. A hospital patient or nursing home resident may not verbally make a decision to withhold or withdraw life-sustaining treatment unless two adults witness the decision. One of the adults must be a healthcare practitioner at the facility. If a patient does not now have capacity to make a decision, but made a decision in the past about the proposed health care, the hospital or nursing home will act based on the patient's previously made decision. This is true unless something occurs that the patient did not expect and the decision no longer makes sense. Question: how are healthcare decisions made for a hospital patient or nursing home resident who does not have capacity? The answer: if the patient has a healthcare proxy, the healthcare agent named in the proxy makes decisions. If a patient does not have a healthcare proxy, a legal guardian, or the person highest in priority from the surrogate list, known as the surrogate, makes decisions. Question: what is the surrogate list? The person who is highest in priority is listed at the top. The person with the lowest priority is at the bottom. In order: first, the spouse, if not legally separated from the patient, or the domestic partner. Second, a son or daughter 18 or older. Third, a parent. Fourth, a brother or sister 18 or older. And finally, a close friend. Question: what is a domestic partner? The answer: a domestic partner is a person who has entered into a formal domestic partnership recognized by a local, state, or national government, or this person has registered as a domestic partner with a registry maintained by the government or an employer, or this person is covered as a domestic partner under the same employment benefits or health insurance, or this person shares a mutual intent to be a domestic partner with the patient, considering all the facts and circumstances, such as they live together, they depend on each other for support, they share ownership or a lease of their home or other property, they share income or expenses, they are raising children together, they plan on getting married or becoming formal domestic partners, or they have been together for a long time. Question: who cannot be a domestic partner? The answer: a parent, grandparent, child, grandchild, brother, sister, uncle, aunt, nephew, or niece of the patient or patient's spouse, or a person who is younger than 18. Question: who qualifies as a close friend? The answer: a close friend is any person 18 or older who is a friend or relative of the patient. This person must have maintained regular contact with the patient, be familiar with the patient's activities, health, and religious or moral beliefs, and present a signed statement to that effect to the attending doctor. Question: what if a surrogate highest in the priority is not available to make the decision? The answer: if this happens, the next available surrogate, who is highest in priority, makes the decision. Question: what if a surrogate highest in priority is unable or unwilling to make the decision? Answer: in this case, another person from the surrogate list will decide. The surrogate highest in priority may designate any other person on the list to be surrogate, as long as no one higher in priority than the designated person objects. Can patients or other decision makers change their minds after they make a treatment decision? The answer: yes. Decisions may be revoked after they are made by telling staff at the hospital or nursing home. Decisions to withhold or withdraw life-sustaining treatment in hospitals and nursing homes. Question: what is life-sustaining treatment? The answer? Life-sustaining treatment means that the attending doctor believes the patient will die within a relatively short time if the patient does not get the medical treatment or procedure. CPR is always considered to be life-sustaining treatment. Question: what is CPR? Answer: CPR, cardiopulmonary resuscitation, refers to medical procedures that try to restart a patient's heart or breathing when the patient's heart stops and/or the patient stops breathing. CPR may begin with something like mouth-to-mouth resuscitation and forceful pressure on the chest to try to restart the heart. This may not work, so CPR may also involve electric shock, defibrillation, insertion of a tube down the throat into the windpipe, intubation, and placing the patient on a breathing machine, ventilator. Question: what is a decision to withhold or withdraw life-sustaining treatment? The answer: a decision to withhold life-sustaining treatment is deciding to refuse a treatment before it is provided. A decision to withdraw life-sustaining treatment is deciding to refuse treatment already being provided. Every adult patient has the right to refuse medicine and treatment after being fully informed of and understanding the probable consequences of such actions. Question: how would a hospital or a nursing home carry out a decision to withhold or withdraw life-sustaining treatment? The answer: the doctor might direct staff not to provide or to stop providing certain medicines, treatments, or procedures. This may result in the patient dying within a relatively short time. For example, the doctor might order that a ventilator, which is enabling a patient to breathe, be turned off. In order to withhold life-sustaining treatment, the doctor might issue a medical order such as a Do Not Resuscitate DNR order. This means do not attempt CPR when the patient's heart stops and/or the patient stops breathing. Or Do Not Intubate DNI order. This means do not place a tube down the patient's throat or connect the patient to a breathing machine, a ventilator. A decision could also be made to stop or not to start artificial nutrition and hydration through a feeding tube or an IV. This means the facility will not give the patient liquid food or fluids through a tube inserted in the stomach, or by a tube called a catheter inserted into the patient's veins. Patients will always be offered food to eat and fluids to drink by mouth if they are able to eat and drink. Other kinds of decisions to limit medicines, treatments, or procedures could also be followed. For example, stopping dialysis. Question: will a hospital or a nursing home ever withhold all treatment? The answer: no. Even if a patient has a DNR order or other medical order to withhold life-sustaining treatment, the patient should receive medical care and treatment to relieve pain and other symptoms, and to reduce suffering. Comfort care, also known as palliative care, should be available to all patients who need it. Question: when should a patient get a DNR order? The answer: any adult with decision-making capacity may request a DNR order. However, patients and families must consult with a doctor about their diagnosis and the likely outcome of CPR. Only a doctor can sign a DNR order. A DNR order instructs healthcare professionals not to provide CPR for patients who want to allow natural death to occur, or if their heart stops and/or if they stop breathing. For example, a patient who is expecting to die from a terminal illness may want a DNR order. When successful, CPR restores heartbeat and breathing. The success of CPR depends on the patient's overall medical condition. Age alone does not determine whether CPR will be successful. But illnesses and frailties that go along with age often make CPR less effective. When patients are seriously ill, CPR may not work, or it may only partially work. This might leave the patient brain damaged or in a worse medical state than before his or her heart stopped. After CPR, depending on the patient's medical condition, the patient may be able to be kept alive only on a breathing machine. Question: does a DNR order affect other treatment? The answer: no. A DNR order is only a decision about CPR, chest compression, intubation, and mechanical ventilation, and does not relate to any other treatment. Do not resuscitate does not mean do not treat. Question: what happens if the patient is transferred from a hospital or nursing home to another hospital or nursing home? The answer: medical orders, including a DNR order, will continue until a healthcare practitioner examines the patient. If the doctor at the new facility decides to cancel the medical order, the patient or other decision maker will be told, and he or she can ask that the order be entered again.
Decision-making standards for legal guardians and surrogates in hospitals and nursing homes. How are healthcare decisions made by surrogate decision-makers, including legal guardians? The surrogate must make healthcare decisions in accordance with the patient's wishes, including the patient's religious and moral beliefs. If the patient's wishes are not reasonably known, the surrogate makes decisions according to the patient's best interest. To figure out what is in the best interest of the patient, the surrogate must consider the dignity and uniqueness of every person, the possibility of preserving the patient's life and preserving or improving the patient's health, relief of the patient's suffering, and any other concerns and values a person in the patient's circumstances would wish to consider. In all cases, what matters is the patient's wishes and best interests, not the surrogate's. Healthcare decisions should be made on an individual basis for each patient. Again, decisions must be consistent with the patient's values, as well as religious and moral beliefs. Do surrogates always have authority to make decisions to withhold or withdraw life-sustaining treatment? No. A legal guardian or a surrogate in a hospital or nursing home may decide to refuse life-sustaining treatment for a patient only in the following circumstances. Treatment would be an extraordinary burden to the patient, and the patient has an illness or injury which can be expected to cause death within 6 months, whether or not treatment is provided, or the patient is permanently unconscious. Or the provision of treatment would involve such pain, suffering, or other burden that it would reasonably be deemed inhumane or extraordinarily burdensome under the circumstances, and the patient has an irreversible or incurable condition. In a nursing home, an ethics review committee must also agree to decisions other than DNR based on this bullet point. In a hospital, the attending doctor or the ethics review committee must agree to a decision to withhold or withdraw artificial nutrition and hydration based on this bullet point. How are decisions about life-sustaining treatment made for minors in a hospital or nursing home? The parent or guardian of a patient under 18 makes decisions about life-sustaining treatment in accordance with the minor's best interest. They take into account the minor's wishes as appropriate under the circumstances. For a decision to withhold or withdraw life-sustaining treatment, the minor patient must also consent if he or she has decision-making capacity. It is assumed that an unmarried minor lacks decision-making capacity unless a doctor determines that the patient has the capacity to decide about life-sustaining treatment. Minors who are married make their own decisions, the same as adults. What if an unmarried minor patient has decision-making capacity and he or she is a parent? What if he or she is 16 or older and living independently from his or her parents or guardian? Such minors can make decisions to withhold or withdraw life-sustaining treatment on their own if the attending doctor and the ethics review committee agree. Resolving disputes in hospitals and nursing homes. What if there are 2 or more persons highest in priority and they cannot agree? For example, what if the adult children are highest in priority and they disagree with one another? In this case, the hospital or nursing home staff can try to resolve the dispute by informal means. For example, more doctors, social workers, or clergy could discuss the decision. Also, every hospital and nursing home must have an ethics review committee. The case may be referred to the Ethics Review Committee for advice, a recommendation, and assistance in resolving the dispute. The hospital or nursing home must follow the decision of the surrogate that is based on the patient's wishes, if they are known. If the patient's wishes are not reasonably known, the hospital or nursing home must follow the decision that is in the patient's best interest. What if a person connected with the case does not agree with the surrogate's treatment decision? This could be the patient, a healthcare worker treating the patient in the hospital or nursing home, or someone lower in priority on the surrogate list. Again, the hospital or nursing home staff can try to resolve the dispute by informal means. If that is not successful, the person who disagrees could request help from the Ethics Review Committee. The person challenging the decision-maker can ask that the Ethics Review Committee try to resolve the dispute. This person could present information and opinions to the committee. The Ethics Review Committee can provide advice and make a recommendation and can provide assistance in resolving the dispute. Are the recommendations and advice of the Ethics Review Committee binding? No, the recommendations and advice of the Ethics Review Committee are advisory and non-binding, except for 3 very specific types of decisions. The Ethics Review Committee must agree with the decision in the following 3 situations. A surrogate decides to withhold or withdraw life-sustaining treatment other than CPR from a patient in a nursing home. The patient is not expected to die within 6 months and is not permanently unconscious. In this situation, the Ethics Review Committee must agree to the following. The patient has a condition that can't be reversed or cured. Also, the provision of life-sustaining treatment would involve such pain, suffering, or other burden that it would reasonably be deemed inhumane or extraordinarily burdensome under the circumstances. A surrogate decides to withhold or withdraw artificial nutrition and hydration from a patient in a hospital. The attending doctor objects. The patient is not expected to die within 6 months and is not permanently unconscious. In this situation, the Ethics Review Committee must agree to the following. The patient has a condition that can't be reversed or cured. Also, artificial nutrition and hydration would involve such pain, suffering, or other burden that it would reasonably be deemed inhumane or extraordinarily burdensome under the circumstances. In a hospital or nursing home, an Ethics Review Committee must approve the decision of an unmarried, emancipated minor to withhold or withdraw life-sustaining treatment without the consent of a parent or guardian. In these 3 situations, life-sustaining treatment will not be withheld or withdrawn unless the Ethics Review Committee approves. What does it mean when the recommendations and advice of the Ethics Review Committee are advisory and non-binding? This means that the surrogate highest in priority can make a legal health care decision. He or she can do this even if another person lower in priority on the surrogate list or others continue to disagree with the surrogate decision maker. What if the hospital or nursing home has a policy based on religious or moral beliefs that prevents the facility from honoring a healthcare decision? When possible, the facility must inform patients or family members of this policy before or at admission. When the decision is made, the facility must cooperate in transferring the patient to another facility that is reasonably acceptable and willing to honor the decision. Meanwhile, the facility must honor the decision unless a court rules otherwise. If the decision goes against one health care practitioner's religious or moral beliefs, the patient must be promptly put under the care of another health care practitioner. DNR orders outside the hospital or nursing home. If a patient is not in a hospital or nursing home, how can the patient get a DNR order or DNI order? The patient's doctor can write a DNR order on a standard form that has been approved by the New York State Department of Health, DOH 3474, Non-Hospital Order Not to Resuscitate. A doctor can also sign a non-hospital DNI order in addition to the non-hospital DNR order using the DOH 5003 form called MOLST, Medical Orders for Life-Sustaining Treatment. EMS, home care agencies, and hospices must honor these orders. If the patient is at home with a non-hospital DNR order or MOLST orders, what happens if a family member or friend calls an ambulance? If the patient has a non-hospital DNR order and it is shown to emergency personnel, they will not try to resuscitate the patient or take the patient to a hospital emergency room for CPR. They may still take the patient to the hospital for other needed care, including comfort care to relieve pain and reduce suffering. What happens to a DNR order issued in the hospital or nursing home if the patient is transferred from the hospital or nursing home to home care? The orders issued for the patient in a hospital or nursing home may not apply at home. The patient or other decision maker must get a non-hospital DNR order on the DOH 3474 form or the DOH 5003 MOLST form. If the patient leaves the hospital or nursing home without a non-hospital DNR order, it can be issued by a doctor at home.
About the Healthcare Proxy Form. This is an important legal document. Before signing, you should understand the following facts. This form gives the person you choose as your agent the authority to make all healthcare decisions for you, including the decision to remove or provide life-sustaining treatment, unless you say otherwise in this form. Healthcare means any treatment, service, or procedure to diagnose or treat your physical or mental condition. Unless your agent reasonably knows your wishes about artificial nutrition and hydration, nourishment and water provided by a feeding tube or intravenous line, he or she will not be allowed to refuse or consent to those measures for you. Your agent will start making decisions for you when your doctor determines that you are not able to make healthcare decisions for yourself. You may write examples of the types of treatments that you would not desire and/or those treatments that you want to make sure you receive. The instructions may be used to limit the decision-making power of your agent. Your agent must follow your instructions when making decisions for you. You do not need a lawyer to fill out the form. You may choose any adult 18 years of age or older, including a family member or close friend, to be your agent. If you select a doctor as your agent, he or she will have to choose between acting as your agent or as your attending doctor, because a doctor cannot do both at the same time. Also, if you are a patient or resident of a hospital, nursing home, or mental hygiene facility, there are special restrictions about naming someone who works for that facility as your agent. Ask staff at the facility to explain those restrictions. Before appointing someone as your healthcare agent, discuss it with him or her to make sure that he or she is willing to act as your agent. Tell the person you choose that he or she will be your healthcare agent. Discuss your healthcare wishes and the form with your agent. Be sure to give him or her a signed copy. Your agent cannot be sued for healthcare decisions made in good faith. If you have named your spouse as your healthcare agent and you later become divorced or legally separated, your former spouse can no longer be your agent by law unless you state otherwise. If you would like your former spouse to remain your agent, you may note this on your current form and date it or complete a new form naming your former spouse. Even though you have signed this form, you have the right to make healthcare decisions for yourself as long as you are able to do so. and treatment cannot be given to you or stopped if you object, nor will your agent have any power to object. You may cancel the authority given to your agent by telling him or her or your healthcare provider orally or in writing. Appointing a healthcare agent is voluntary. No one can require you to appoint one. You may express your wishes or instructions regarding organ and/or tissue donation on this form. Concerns, problems, complaints about your hospital care. If you have a concern, problem, or complaint related to any aspect of care during your hospital stay, speak to your doctor, nurse, or hospital staff member. If hospital staff has not resolved the problem, you may contact the New York State Department of Health by mail or phone. You may call the toll-free number 1-800-804-5447, or you may file a complaint in writing and send it to New York State Department of Health, Centralized Hospital Intake Program, 433 River Street, 6th floor, Troy, New York, 12180. Questions or comments? Online at hospinfo@health.state.ny.us.